Well, let's start off. One of the things that I need to cover is that January 6th has changed the trajectory of American politics, I think, forever. We've been talking about that, but a couple of things I need to cover in terms of liability, then we'll get to the other issues. The first issue has to do with the fact that uh, insurrection is probably excluded from liability coverage. Most people don't realize this, that when you're involved in any type of issue, most of the time it's covered by liability insurance. Even if you commit a particular act, there may be a duty to defend, but not a duty to pay. But when you're dealing with insurrection, most of your policies, like with the State Farm, they have an exclusion clause for insurrection. If they have a riot and vandalism, it covered. Now, the reason that's important is that there's all counter potential claims in lawsuit that could be derived from this threat to the termination of democracy. You have the bystander type coverage, where you have negligent infliction of emotional distress. They had people dying. They had people hurt. You had this massive takeover of the government. So, having said that, there's probably 1,000 or so claims that could be filed against these domestic terrorists for invading the Capitol. And I try to throw that out there because I want to make the distinction between riots and protests that run amok versus an insurrection. An insurrection, as you folks know, is an attempt by certain folks to overthrow the federal government. And so we saw that firsthand in the sense that they tried to throw out the electoral college votes and by usurping the authority of the vice president to simply announce the results. Now, having said that, I want to get that out there because it's a big issue. And I think that this week we saw a massive amount of litigation filed, panel members. As you saw, the big issue that came out is that the so-called voter motor fraud folks on TV with Fox, and they all got sued. What do you think about that, starting with John Sweeney? Did you watch that?
Yeah, you mean the company that manufactures the voting machines? You're referring to that?
Yes.
Suing.
Sematech and
I read an article this morning where in the New York Times where Lou Dobbs, the very popular Fox radio host, was fired. They didn't say fired; they were before this whole lawsuit by the company that manufactures the voting machines brought the suit. That Lou Dobbs was on his way out or going to be reassigned. That's a bunch of baloney. His firing was a direct result of his just railing on and about voter fraud and these machines are rigged, and what it did was it really hurt the business reputation of this company that manufactures these machines. So there was a $2.7 billion with a B dollar lawsuit filed against Lou Dobbs, Fox, and several other people for defamation. So I think that's very significant. I think it's a great lawsuit, and it will be a tremendous deterrent. The outcome of this lawsuit will be a tremendous deterrent for people just like even journalists who just wholesale buy into claims they know are fraudulent and then spew them to the people that eventually led to what happened on January 6th at the Capitol. So I think that I think it's a viable lawsuit. I think it's an important lawsuit, and I'm going to watch it.
Attorney Ryan, did you observe that this week?
I missed that, but I know the issue we're talking about, and I agree with Mr. Sweeney. I think it's a viable lawsuit. We addressed this matter 2 weeks ago on this program somewhat, and that is dealing with the ability of a person to provoke, instigate, and as McConnell said about his friend Donald Trump, he promoted, provoked, and lied caused the people to the capital. Now, doing that, he's liable. He's vicariously liable for those acts of the people who did that and the damage and the harm that was caused. Just in the case we spoke of 2 weeks ago with the former federal judge Ansel Hagerty, who presided over the trial of Tom Metzger, an avowed racist who had an organization called the WAR, White Aryan Resistance. He promoted hatred and violence towards immigrants and minorities. And he promoted it to the 100th degree. He talked about it and he spewed his hatred through the videos. And this racist group from Portland was following it. And they saw this 27-year-old, very innocent young man who was a student, just arrived in America. And they killed him. They beat him to death with bats and sticks. And Metzger said they should give him acknowledgement and award for doing their duty, on their civic duty. So I think that the former man, Mr. 44th or whatever number he was, is vicariously liable for what he instigated and the people that he provoked to do those violent acts. So I don't believe that he was protected because of some immunity that they're talking about that was decided by a Supreme Court 20 years ago. So that means to me it wasn't that solid. But I think that he should be sued for everything while he was before he got in office and what he's doing now. That was a long answer to your question. But yes, I agree with John Sweeney.
Attorney Banks, your thoughts?
Absolutely. I agree with what John has set forth. I did see an interview between the CEO of the election machine manufacturer, and I think that the defamation suit is well grounded, and I plan to follow the case very closely. Certainly with the false allegations made regarding the election machine manufacturers, there's potential damage. Of course, damage has already been done to, their brand, their name, and their reputation. And so false allegations relative to the machines being rigged and other misrepresentations laid the groundwork for this lawsuit. And with respect to Milton's comments regarding the Metzger case, where, as you know, Mr. Metzger was forced to pay a judgment was rendered against Mr. Metzger for $12 million in a civil action for inciting the murder of the Ethiopian student. The distinction, Milton, is that Mr. Metzger was not the president of the United States, and arguably, acting within the scope of his official duties, and therefore immune from liability under the concept of absolute immunity.
Well, we have a couple very technical questions raised by our guests. We get them through YouTube, we get them through Facebook, but one thing I need to point out to the first question is that when you have these type of lawsuits, the cost of defense is extraordinarily high. For example, a typical products liability case that we do, the manufacturer may pay between $2 to $5 million to take the case from the lawsuit up through the first day of trial. However, in these type lawsuits, See, you don't get the insurance rates of $200 an hour. These lawyers are charging $1,500 an hour, and their paralegals are $500. So what happens is that you could have an unlimited amount of depositions. I was just thinking about it because you had over 1,000 folks. In theory, you could depose them all. This discovery process may cause about 30 or 40. But the question our callers want to know right away to this panel: can the government be sued since Trump caused the riot?
So
Who wants to start off answering that? They want to know, can the United States government be sued since Trump is the person that caused the riot?
Well,
in this case, the insurrection.
Right. There's all kind of immunity that the president enjoys, that the government enjoys. That's a very, very difficult question. And the short answer is no, the president probably cannot be sued because he's cloaked with so much immunity. Without going into a real long dissertation, unfortunately, that is probably the case. However, some of his cohorts, Rudy Giuliani is a private citizen, and what he said was probably far worse than what the president said that day. So if I were Rudy, I would be shifting my assets to a place where my creditors down the line couldn't get a hold of them. They'll probably be able to unravel everything down the line, but he's going to end up a man with not much money. And by the way, this defamation lawsuit against Fox, there are going to be punitive damages asked for, which is damages for punishment, which could go far and above the $2.7 billion that is being asked for business or compensation for the loss of their business or the damage to their reputation. So Fox could be a hook for, hundreds of millions of dollars in punitive and general damages. By the way, the company that brought the lawsuit is called Smartmatic, Smartmatic. And there's a great article in the New York Times this morning about that, about Lou Dobbs being ousted at Fox over what he did. So.
For the sake of discussion, I'm going to disagree with John Sweeney. So I agree with him 99.99% of the time. But in this case, I'm going to look at the other side and say that the liability of an individual and of a body that and employs that individual, it has to be looked at. Here you have a man that started out being a crook, continued being a crook, and his factors and his actions were endorsed and done and supported by Mitch McConnell and the GOP and the government throughout his term over this country. 4 years, essentially. And this was condoned. It's just like in comparison with other agencies or situations where the leadership condones a pattern and practice. It would be my counter argument to what John is saying. Excuse me. It's not absolute immunity of the government to stand by and watch him amongst the people here. For one, we know he can be sued, and we know the government can be sued. Would it be a viable lawsuit? I think possibly yes.
Well, as a general rule, and I'll let Attorney Banks, the federal statute in terms of liability allow for direct cause of action against individuals, but in general, like the Constitution Amendment prevents suits, for example, against the United States, but you have the direct cause of action like under 1983 against the individual actors. And because you sue the individual actors, say, for example, Donald Trump, if you get past the quasi-immunity defenses under the 1983 theory, then you're able to get proceeds paid by the federal government by suing the individuals. Because most of the time, like when we sue police, if you sue police officers, for example, for killing somebody in state court, you can sue the city. But if you sue them in federal court, you have to name the individual officers, and that's the difference in terms of the area and the location of the lawsuit and the theory of recovery. But go ahead, Attorney Banks.
Well, I was going to add that historically, the U.S. government has been immune from liability in civil actions, and also Congress enjoys that same absolute immunity for acts that are within their legislative authority. With respect to the president, however, there have been cases decided by the Supreme Court that address whether the president has absolute immunity. And the landmark case of Nixon versus Fitzgerald, and it was a 5-4 decision, so it was hotly debated, held that the president in that case had absolute immunity for his official act, and the rationale was rooted in a theory that the immunity was implied in the Constitution, as well as rooted in separations of power. And the court went on to say that the remedy for and these are my words, insurrectionist president would be impeachment, and that there's also constant scrutiny by the press of the president's actions, and that a president's desire for re-election and their legacy, as well as congressional oversight, would be deterrents against a president engaging in illegal conduct. And so for that reason, the court held that President Nixon was entitled to absolute immunity in this particular case, the Nixon case, where a executive branch member testified during a congressional hearing. He was a whistleblower, and subsequently Nixon authorized his firing. And in that case, it was held that the president had absolute immunity because that decision with respect to the termination of a executive branch employee fell within the scope of his official duties.
And if Trump did on January the 6th, Anita Banks, fell outside of his official responsibility or his duty, would he be liable?
Well, the court addressed several aspects which would suggest that if his actions on January 6th were deemed to be outside of his official authority, then he could be subject to liability. And I guess the question becomes that whether or not those actions in allegedly inciting insurrection and violence and overturn of the United States government fell within the, quote, outer perimeters of his official responsibility.
Right.
Well, for the benefit of the audience, let me give you some clear examples of what we're talking about now. We're talking about immunity and going outside. Let me give you the clearest example. Judges have what is called judicial immunity, which means that you can't sue them for anything in their official capacity. But what occurs in the fact that a judge goes out and causes a traffic accident? So the judge could be doing a trial and they have to run home to get some medication, for example. He runs through a red light and causes an accident. Now, in that situation, although he's a judge and maybe doing a trial, but he's driving a car and caused an accident. And because of that, the judge is liable like anyone else for causing the accident. And so that's an example of doing something outside of the judicial immunity or the immunity that you're talking about. Just give you a glad example. Go ahead, though. Oh, I'm sorry. Now, at this time, for the radio audience, we're going to take a short commercial break. We'll be back in 3 minutes.
I don't
Milton,
know of his judicial, but his duties as a president, one could be when they stand up on a pulpit and incite people to go and do some action. That's not signing a bill. That's not following the law. That's going outside of the perimeters that he's protected in.
I agree. I
Well,
agree with
arguably inciting insurrection and sedition, for which, yes, impeachment would be a remedy. I agree. And when you talk about intentional torts, for example, the example that Nate just raised, my opinion would be that defamation,
Sonia.
for example.
Go ahead.
I'm sorry, Renita, I missed that, Nate Gill.
I'm sorry.
My position would be that defamation, for example, would fall outside of official duties.
Right. That's all I'm saying, folks, that I don't
Yeah.
think that absolute immunity that he boasted of going down Fifth Avenue and shooting somebody and you can't touch me. I don't buy that.
Let me tell you, this may be a precedence-setting case. It may make it to, a lawsuit may be dismissed and against the president. It may eventually work its way to the United States Supreme Court. And the United States Supreme Court would probably have to decide whether or not they're going to take it, number one. And if they do take it, the issue is going to be, do we do exactly what you guys were talking about? Do we carve out some type of exception to immunity if you do something so heinous like the president did, is incite a mob to overthrow the very government that he runs?
Also, this one is easy. Could you bundle your home and car insurance with Geico so we could save money? Last thing, just a suggestion. Could you steam clean those carpets?
Milton, your audio has been very shaky this morning. You can hear almost every other word.
If you have too much credit card
Is
debt,
that the radio?
to pay your bills
Yes,
during this
radio.
pandemic, you must hear this message. There is a special program available right
Yes.
now that allows you to settle your credit card debt for a fraction of what you
Yeah.
owe.
Even-
That's right. Millions of
after the
jobs
radio
have been lost
was
due to the virus. Over
Now,
1 million
Producer?
Americans with credit card debt. At JetBlue, we help you qualify for a program that literally wipes out a
Producer?
large portion of what you owe. Just text NEW to 323232 to see how much credit card relief you qualify for. Text NEW to 323232 and we can absolutely settle your credit card debt for a fraction of what you owe. Credit
Could
card
you turn the
companies
sound
will
down
tell you
on the
about this.
commercial?
Text NEW to 323232 and virtually eliminate your
But
debt.
you can turn down
faster
your
than
cell
ever
phone.
possible. You can
Listen
qualify
to
for a
commercial.
monthly payment that will make you smile again. This program is so good, we even guarantee your success. Text NEW to 323232 to see if you qualify. Text the word NEW to
Yeah, that's coming from Nate.
Yeah, I just turned them off. Can you hear me now?
Yeah,
Yes.
Yeah, I just turned the radio off, and I discovered I got this button that my son set up. I could end the radio pro. Okay, but we're still on YouTube. But go ahead.
Well, you also ended the brilliant comment I had prepared for John Sweeney, and I forgot what we were talking about now.
Absolute immunity for president's actions.
Yeah.
All right, so you guys can go back on whenever you're ready, okay?
We're live now. Thank you.
We're ready. Okay, go ahead.
I honestly forgot the response I was going to have for John, but it was
Well,
well.
we're talking about the difference between absolute immunity in terms of things done outside the scope of the immunity protection. As the audience recall, I gave an example of a judge who has absolute immunity for things he's done in a courtroom, decisions that he made, but he went out and caused a car accident. That would be conduct that would be outside the scope of the immunity protection. Now,
Oh, I know. Let me interrupt you, please, if I may, Nate.
Go ahead.
Okay. I was saying, John, that he thinks he has put 3 justices on the Supreme Court, however, and it's his court. But based upon at least an indication with the Supreme Court's response to his attempt to overthrow the election, I don't think he have carte blanche authority or power to get his way. And so he may not be as insulated or supported by this present Supreme Court as we have been led to believe he would be in matters. So that's what I have.
I agree with you, Milton, and the 60 lawsuits that were brought around the country and dismissed summarily proves your point, that he's not as insulated as he thinks he is. He thought he could appoint judges around the country, appoint Supreme Court justices, and that they would do his bidding. And he was sadly mistaken. He was sadly. And I think there needs to be an example made of this president, so this never happens again.
But we don't have kings and monarchs in this country. Yes,
that is so true. And the dissent in the Nixon case pointed out that we're a nation of laws, and no one is above the law. And we've moved away from a time when the king can do no wrong. And in fact, the framers at the Constitution conventions, they intensely debated this issue regarding absolute immunity vested in the president. And they even talked about a hypothetical where, a president committing murder in the street, and that impeachment wouldn't address that issue, and that example really, resonates with the statement that the former president made of him being able to shoot someone, in the middle of Fifth Avenue and not bear any consequence. And that's not true from my perspective. And I think we're going to see some very interesting arguments made on both sides, of course. And from my perspective, immunity depends on the actual act and not the person. And so we saw in a unanimous decision, Supreme Court decision in Clinton versus Jones, that there's no immunity for a president or no absolute immunity from civil litigation arising from events that occurred prior to him taking office. And the court also held that it was not required that even the action be postponed until after President Clinton left office.
Okay, now I distinguished panel, the question that's trending now on our social media dealt with the 1983 that we talked about. For the benefit of people on YouTube, I was referring to the federal civil rights statute, 42 United States Code, section 1983. And what that means is that one can sue a state official or a government official for violation of a person's civil rights under one of the Constitution Amendment, whether it's the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment, First Amendment, it doesn't matter. But the federal statute allows you to sue the individual actor. And but then the question is, and this came up with our gentleman from Nebraska, can you also sue the judge, for example, for sexual harassment? Who wanted to respond to that one?
Can you sue the judge for sexual harassment? I think
so. Can a judge be sued for? Yes.
I'm going to start it off facetiously and say you can sue anybody. Now, would you prevail? I believe that it is outside of the perimeter of his office and his duty to conduct or participate in sexual harassment. He has stepped out of bounds. Let me finish, John, and It's compared to prosecutors. People say you can't sue the prosecutor, but if the prosecutor get in his car or do something outside of his prosecutorial description and get involved in the investigation and the planning of evidence and the this or the that, he's outside of that protected area of what he's allowed to do. That's my argument.
I agree. My father, who was a lawyer, always said that statutory law is based on the common law, and common law is based on common sense. And common sense dictates that a judge, because he has a robe on, cannot, because of that robe, because he's cloaked in that immunity of what he does within the course and scope of his duties as a judge, he can't step over his bounds and commit murder, sexually harass people, sexually assault people. So I would agree with you that that is beyond, that a suit would prevail against a judge who is charged with sexual harassment.
Thank you.
Attorney Banks, you have any comments?
I would agree with everything that my colleagues have stated, that there wouldn't be any absolute immunity for a judge in the example that was given with respect to sexual harassment or other intentional torts that fall outside the scope of a judge's authority as a judge. Defamation, for example. And I think that was made clear in the Clinton versus Jones case.
And also, for the benefit of our YouTube folks, judges have a judicial code of ethics that is pretty stringent. It's most states adopt a model code which covers 5 basis areas. But the problem with that, if a judge was adjudicated to engage in sexual harassment, he'd be in violation of the judicial code, and the judicial code would probably mandate some type of potential suspension or removal from the bench. So, it's a two-pronged problem with judges who engage in misconduct. Their judicial code is, in terms of profession, the judicial code is probably one of the most severe of all the profession. The legal profession code is pretty strict in terms of compliance, but judicial code even has some more pitfall for judges. Now, we've seen a departure of that with the U.S. Supreme Court. It seems like they get to interpret whether or not their conduct is inappropriate, but most judges don't have that same type of protection to being the highest court in the land. So I agree with our distinguished panelists. Judge can be sued for sexual harassment like a person because it's the individual claim, and that conduct generally is deemed outside the scope of judicial decision. Okay, now the next issue has to do with, we touched this briefly before, that is one of the biggest problems we're seeing now in the legal profession, we're talking about legals of today, is there's a massive amount of litigation involving COVID. There's lawsuits popping up everywhere, and something that we're going to have to deal with. And okay, you said something, Attorney Sweeney. What about under color law, can an official violate civil rights? I guess what they're trying to find out is what constitutes under color of law and for an official to violate the civil rights. Can anybody answer that?
Yeah, the term is color of authority and not color of law, it's color of authority. That means that if a police officer is doing something within his official duties as a sworn peace officer, that refers to the term color of authority. I hope I answered the question. Did the caller want to know what color of authority means, or color of law?
John, I
go ahead.
I would add that that term color of law, John, has become popularized, at least in my mind, by a book that I read a couple of years ago because of a lawsuit I had against the city of Santa Monica under color of law, where they study the government and the court, legislation and laws and rules that provided for discrimination and housing segregation and Jim Crow laws. And that kind of popularized that term under color of law, how these very discriminatory anti-minority laws were set up and implemented and carried out throughout our country under color of law. So it is a very popular term, but I understand what John is saying.
Okay. Now back to the insurance component of this, and I want to make everybody aware of what the problems are with COVID. We are seeing the largest amount of lawsuit probably in the history of our country now in terms of COVID lawsuits. They're just popping up everywhere, and they run into different categories. But the one that is most interesting to me are the business, the BOP policy, business overhead protection. There's a series of lawsuits, and the decisions have been going both ways. And what I mean is that let's talk about last year when we started this pandemic. Some of the restaurants were forced to shut down. I think in your neck of the wood in California, they were shut down for a longer period of time. Is that right?
Yeah.
The restaurants.
Yeah.
So,
yes.
So what happened is the restaurants now have these massive lawsuits pending everywhere, where they're suing their insurance company, and because when under your BOP policies, usually if you're shut down for 2 or more days, some policies have maybe 3 days, some may have 7 days. Our policy in my law firm is a 2-day policy. We're shut down because of certain things for 2 days or more. You can file a business overhead claim. However, in our situation in Indiana, law firms were not shut down, but restaurants were. And so we had a few people that were called, for example, and they want to know whether or not their insurance policy will cover the shutdown. And the answer, it depends. And because the cases, they're going 50-50. It's the most amazing thing I've ever seen. In each state, I saw a good decision out of Louisiana, a great decision out of Ohio, one out of New York, and I saw a bad decision out of Florida. But the point is that some of these cases are going forward, and people are collecting billions of dollars on these business interruption claims. Because I know we have a lot of people out there in radio land. You probably own a small business, and one of the things that you may be concerned about is that when the pandemic occurred, the government, the state and local government, caused a shutdown of your business. And we know that we had the federal government dip in and provide some protection, but you have to look at your individual policy, consult with your lawyer to find out whether or not you have potential claim for the business interruption. And I want to get that out there because that's one of the things that I see on a regular basis. Now, the other part about this, go ahead.
No, finish
Attorney
your
Banks.
point, Attorney Lee.
Well,
I was just going to say that a plethora of cases have been filed across the United States. Companies are continuing to file business interruption lawsuits against their insurers for claims arising from the state and local government shutdown orders in response to the COVID-19 pandemic. And these cases are being filed in both state and federal court. They've been filed in almost virtually every state. And nearly 75% of the cases have resulted in dismissals, but Attorney Lee has referenced some cases that have ruled in favor of the restaurants. And there are 2 opinions, one in New Jersey, another in North Carolina, that found in favor of the policyholders. And in most of these policies, there's a requirement of a physical loss or physical damage. And New Jersey, a case in New Jersey found that physical loss or damage was not required under New Jersey law. And so this is particularly important. I'm glad you brought it up, Attorney Lee, to small business owners out there that own restaurants and bars and other retail establishments.
Yeah, go ahead, Attorney Grimes.
Yeah, I'm sorry. There's a lawyer out here in California who went to court a couple of weeks ago, and he was able to set aside the governor's shutdown of the restaurant. I think, John Sweeney, correct me if I'm wrong, but I think his argument was based upon it was capricious and arbitrary to make that decision. They didn't have enough proof that it was in fact required to protect the public. He's an African-American lawyer, to my pride and thankfulness, that was a very articulate young man who defended and represented restaurants, the restaurant organization that took on this lawsuit. So they were, very joyful for the outcome of that lawsuit. But as a personal thing, I was leaving my doctor's office yesterday about 4 o'clock, and I was Ubering down Robertson Boulevard. And it was such a joy to see people sitting out at the tables at the restaurant. I'm going, damn, I've missed that. Taste the food almost, man. I'm serious. It was like, wow, we're getting back. But I won't, sitting here this morning, I won't sacrifice my safety for that joy, but it sure was a pleasing sight and a relief.
I followed that very closely, the decisions in California about the restaurants being allowed to reopen for outdoor dining. You still can't go inside the restaurant. You can dine outside, al fresco, but I think this decision by the governor to open that back up to outdoor dining had a lot to do with the fact that a third of Californians polled said that Governor Newsom should be recalled.
Right.
So he's in the fight for his political life. And right during the escalation of this coronavirus pandemic in California, the restaurants opened back up. That really concerned me like it did you, Milton.
And he got caught up in the hypocrisy of dining during the pandemic and during his closure. I think it was during his closure order. So they caught him dining out in wine country, Nate, enjoying the dinner. But Bonita don't have the pleasure that John and I have out here on the West Coast of being able to enjoy like 76 degrees today and outside dining.
Right.
That's true.
Well,
and even the outside dining, here in Illinois that was set up, with the tents. Now with a foot of snow on the ground, those outside tents have turned into snow igloos.
One thing
literally.
I like
there's help on the horizon, and I want to ask Mr. Grimes a question because I was talking to Nathaniel before the show started and went on the air, and we both talked about taking our first dose of the Moderna vaccination. And we asked, and you weren't on yet, Milton. We asked, did Milton do it? So I know that several weeks ago, when we were discussing the skepticism of African Americans to take this vaccination, we had different opinions and based in history. So my question to you, Milton, is: have you, if you can disclose this, if you feel comfortable disclosing this, have you taken your vaccination?
Having sort of Anita Banks' response to questions and recognizing and respecting her seeking of research and evidence before she spout a word out. I prepared myself for this. And I, first of all, would like to assert my Fifth Amendment right. You see?
Oh, boy.
Well, let me just say,
So
go ahead.
I haven't finished now. With that said, I want to protect myself with the Fifth. Over here, my doctor talked to me about it yesterday, and he said, just hold your breath. Just like this needle we put it in your arm, man. I go, you got to take my blood. He said, well, we're going to do it up here, and it's no different. So my daughter's going to set up another appointment for me, okay, to do the shot. I don't 100% in agreement with you. I'm still watching how long you and Nate and Vanita are going to last, but hopefully I'll know by the point.
Well, I like to report that I did take a shot under relaxed rule, and I had no side effect. And the thing about it though is that my initial thought process when they were developing this was that I'll sit on the sideline and set up a litigation. But when I discovered that they put all kind of barriers to sue, I say, what the heck? You know, either you get some protection or you risk dying. So it was an easy decision.
Matter, right?
I'm sorry?
You got this new strain that the vaccination may not be any protection to.
Well, you're here for now, Milton. You're here for now.
See, what I saw is that because you have mutation, but you have to get protection for what we know is available. What most people don't realize, when they take the flu shots, I did a jury trial on this, and I didn't really realize this until I did the jury trial. Even flu shots only protect you against 70% of the viruses in the past, historically. We had one of the world-renowned expert, and I didn't realize that there will be maybe 20 potential strains of the flu. And the government will project the 3 most likely to hit the United States. And so they prepare a vaccination product for the top 3. But the top 3 was 70% of the potential viruses that will hit the States. And so some people still get the flu because that vaccination will cover them against the top 3, but not the 17 or 16 bottom 16. So,
and Vanita has promised me Henry Aaron's autopsy report too, so I'm still waiting for that, Vanita.
Okay.
I'm just teasing Vanita. No, she hasn't.
Well, the
There's one
scientists were hoping
question.
for. Go ahead with the question.
There's one final question that our audience want to know on YouTube about if the employer doesn't follow protocol and fire someone as related to COVID. In other words, they put the employees at risk and violate the local or state mandate. Can that person then file a lawsuit for wrongful termination?
I don't know if there's enough facts to answer that question, but if I got the question correctly, the caller, the listener, wants to know if a wrongful termination suit is viable if the employer fires someone because of what?
Well, let me give you an example. That they're talking about. You work at a restaurant, and the state, most governments say it's mandatory mask for everyone, and there must be a barrier. So an employee say, the heck with that. We're going to not have the barrier, the separation, and I still want you to wait on the customers. And the employer say, well, I'm not doing that. I want to be at least 6 feet away, and the person won't agree, and so the
that's a difficult question. I got the question now. I don't think there's any clear answer to that, but I tell you what, I think that, and I don't do employment, but if I were an employment lawyer, I would take that case on. You can't make someone risk their health to work at your business, and then because they won't do it and follow safety guidelines, fire them. There's an analogous situation, Milton, you may have read about in the LA Times this morning, where there's an outbreak of COVID cases, and not cases, but infections, and actually a couple of deaths at the downtown courthouse in Los Angeles.
That's what I asked.
One of the things a judge did in a criminal case was a police officer who came to testify had a mask on, and all the jurors had masks on. And then the defense attorney for a person charged with a crime said to the judge, my client is being denied his constitutional right because the jurors can't assess the witness's credibility with this mask on, because that's a huge thing, is to assess the credibility. Right. Look at him, see his body language, see his facial expressions, and that's denying the constitutional right of the defendant. Well, the judge turns to the police officer who was testifying and says, do you feel comfortable taking off your shield and your mask and testing? He said no, and he doesn't, and people the jurors filed a judicial complaint against the judge. So, and I think they're absolutely right. You can't put jurors in jeopardy, just like you're answering the listener's question. You can't put an employee in harm's way because he wants to be safe. He has to choose between getting a paycheck and dying, and his choice was to stay alive. I think that would resonate with the jury.
And I think those facts constitute what we call in employment law constructive discharge. Where the employer makes the working conditions so unbearable that it forces an employee to resign or retire. Because if you voluntarily quit, then you're not entitled, access to unemployment, and you're not able to successfully sue for wrongful termination. But in the case that the caller is asking about, if an employer fails to follow safety guidelines, from my perspective, that will constitute a constructive discharge of the employee. And there are probably already cases percolating, regarding this issue.
The confusion and inequities and not knowing what we're doing was epitomized last night in a National Basketball Association game with Brooklyn and the other team. But Kevin Durant couldn't start because of protocol. Then halfway of the game, they put him in. And then they took him out and isolated him in quarantine. During the game, he was removed. And it's like, he's confused. The public is confused. But when I see these young men and women entertaining us, I'm excited and my boredom is subsided for a minute. But I think about, you see them in each other's face. You see the referees without the mask. The coaches got on the mask. It's a crazy situation we're in this country, trying to deal with this thing and go on about our daily lives. We don't know what we're doing, y'all.
We're seeing lots of cases being filed, COVID-19 related lawsuits against employers, and there are about 5 categories, including failure to provide a safe work environment, discrimination claims based on disability and age, leave claims under the Federal Medical Leave Act, retaliation and whistleblower claims. And there are just lots of claims related to providing a safe working environment.
Wow, that's incredible. Well, with that note, I'd like to thank our outstanding guests who devote their time and energy to help educate the public on the important issues of the day. A special guest weekly guests, Milton Grimes, John Sweeney, and Vanita Banks. I'd like to thank all of our audience in both radio, YouTube, Facebook. Thank you for listening in. And we will tackle the legal issue of the day. And may God bless and keep you and stay safe until we meet again. Thank you for listening.